Those political actors who, as in the days of the League, threaten the multilateral system or intend to withdraw from parts of it, the sirens of historical experience ought to ring clear. We will not sit idly by, for we have so much to lose, so much to protect, and our rights, the rights of others, the very future of our planet, must not be thrown aside by these reckless political profiteers.
Among the many groups bent on the destruction of Western civilization, those that conceal their blatant anti-white policies behind humanitarian rhetoric deserve a special place in hell. From atop their pulpit, human rights organizations act as the instrument of a new imperialism that is the main obstacle to national sovereignty. Human rights are not some abstract philosophical concept. They are enshrined by international law, and as their scope increases, so too does the supranational apparatus needed to ensure their universalization. The Lockean claim, one of unfathomable hubris, that man by virtue of birth alone possessed inalienable, God-given rights, was the philosophical precedent for the United Nations Declaration of Human Rights in 1948. The most egregious post-Enlightenment heresy is the transfiguration of God into a bureaucratic behemoth as the ultimate arbiter of righteousness on earth. Human rights are no longer God-given. Rather, they are imposed by binding resolutions and multilateral agreements under the all-seeing eye of benevolent watchdogs and committees. Canada, along with the vast majority of the nations of the world, has ratified 7 of the United Nations core human rights conventions. Both the Canadian Human Rights Act of 1977 and 1982's Canadian Charter of Rights and Freedoms emerged as a direct result of the UN's Declaration of Human Rights and are, in essence, its embodiment at a national as opposed to an international level. International human rights law has often been used as a legal precedent by shysters and hostile ethnic groups in order to effect change in Western nations. Such is the case for Canada's immigration policy. In Dr. Ricardo Duchesne's harrowing account of Canada's spiral of radicalization, he notes, "In the same year of 1947, the Minister of External Affairs suggested that the Chinese Immigration Act of 1923 could not be justified under the UN Charter which Canada had signed and which called for an end to discrimination based on race, religion, and sex. Diplomatic pressure from the Chinese government then led the Canadian government in the same year to terminate this act." We can begin to understand how the all-encompassing nature of human rights can serve to subvert ethno-protectionist legislation under egalitarian pretenses. Once Canada pledged to end discrimination based on race in internal affairs in compliance with the UN Declaration, it could then be argued that favoring immigrants of European descent was also a form of discrimination. Those responsible for the Fair Employment and Fair Accommodations Practices Act of 1954, which forbade white Canadians from living in racially homogeneous communities, also pointed to the Universal Declaration of Human Rights, notably Articles 13 and 23, as a legal precedent. Unsurprisingly, despite the UN's self-proclaimed mission to end discrimination based on race, it also clearly states that this does not apply when discrimination is in favor of marginalized, i.e. non-white groups. Take the International Convention on the Elimination of All Forms of Racial Discrimination, for example, ratified by Canada in 1970, Article 1. Special measures taken for the sole purpose of securing adequate advancement of certain racial or ethnic groups or individuals shall not be deemed racial discrimination. That sounds strikingly similar to both affirmative action in a general sense and, more specifically, Canada's Gender-Based Analysis Plus. However, it is Article 7 of this convention that is the most troubling. State parties undertake to adopt immediate and effective measures, particularly in the field of education, culture, and information, with a view to combating prejudices which lead to racial discrimination and to promoting understanding, tolerance, and friendship among nations and racial or ethnical groups. As the quintessential UN lapdog, is it any wonder that Canada's education system, news, and entertainment media are saturated with multiculturalist propaganda? The Immigration Act of 1978 is another example of a piece of Canadian legislation being, in many areas, a carbon copy of a pre-existing UN document. In this case, the Convention relating to the status of refugees, which was ratified by Canada in 1969. In the case of the aforementioned Convention on Refugees, Article 32 forbids a country from expelling refugees except on grounds of national security. Article 33 prevents a country from deporting a refugee, legal or otherwise, to areas where his life or freedom may be threatened for any number of reasons, including his political opinions. Finally, Article 34 compels member states to fast-track the naturalization process and to reduce as much as possible their associated costs. It is clearly stated that these provisions are, quote, not dependent on the lawful residence of refugees in the territory of a contracting state. Amnesty International Canada refers to these provisions when it states that the USA is, quote, not a safe place for refugees. In an article on its official website, it describes the Trump administration's executive order on illegal immigration of January of this year as a violation of numerous binding international refugee and human rights legal provisions. Clearly, a nation simply enforcing its immigration laws on a unilateral basis is incompatible with increasingly restrictive international human rights legislation. The normalization of sexually deviant behavior has led to the reinterpretation of the Declaration of Human Rights, specifically Article 14, to include LGBT status as a legitimate grounds for asylum, as per the so-called Yogyakarta Principles of 2006. The Canadian government, characteristically, has gone above and beyond to add Q+, or questioning, to the LGBT refugee category, leading to appropriately confused statements on the Ontario government's official white genocide portal, settlement.org. You do not have to be out as LGBTQ+ in your country or have already experienced persecution to claim refugee status. You should be aware, however, that you might have to prove you are LGBTQ+. Ignoring the obvious absurdity of proving that one is trans or questioning, one can imagine how such a policy could facilitate fraudulent refugee claims. Another refugee-related human rights document, the UN's Convention on the Reduction of Statelessness, was ratified by Canada in 1978. Referring to the Universal Declaration of Human Rights, Article 15, which states that everyone has the right to a nationality, the Convention aims to prevent statelessness by requiring states to automatically grant citizenship to children born on their territory who would otherwise be stateless. It also prohibits the withdrawal of citizenship from individuals when doing so would result in statelessness. Statelessness can be due to a number of reasons, including the lack of personal identification, regime change, or administrative obstacles caused by conflict or even illiteracy. According to the UN Refugees Agency's own calculations, at least 10 million people around the world are currently considered to be stateless. The ongoing migrant crisis is only exacerbated by the United Nations and other human rights organizations' philanthropic overreach. According to international law, criminalizing, detaining, denying access to public education, healthcare, and social security to illegal immigrants is already considered to be a violation of their fundamental human rights. If left unchecked, the current human rights framework will lead to the total emptying of the Third World and subsequent resettlement in the West. Human rights, by virtue of their supposed universality and supranational character, heavily restrict a country's sovereignty, border security, and ability for its people to decide its own demographic destiny. Under international law, egalitarian propaganda, affirmative action, and open borders are justified according to the logic of human rights. It follows that, for the white race and culture to be preserved, they must be abolished. Fortunately, the Canadian Human Rights Commission on its official website offers a glimmer of hope. On the subject of human rights, it states, "Nobody can give them to you, but they can be taken away."